efficiency
Why?
because all of them make the game really efficient.
I see. Well, that's a good reason to think that. It says I'm offline. Why am I offline?
Makes you go bye.
This says I'm excellent connection. Well, hey, looks like I've got 2 viewers. Hi, it's me, Know Nothing Attorney. As always, I profess to know nothing and aim for a high confidence at everything. I invite you to know nothing with me because it's only in embracing that you know nothing that we can learn anything. Tonight, we are working on some video scripts so we can actually have some shareable videos, something bite-sized that's digestible. As always, we've got our slides going. Give you some topics.
I'm here.
Well, not as always, but Lore is here. Lore's with us tonight.
As always, I listen every other week.
You are in most streams so far.
Yeah.
That's gonna change for the coming week. I do need to update something real quick. And that is our grassroots slide. If I can find where our slides are. There we go. Days since launch, no longer 6, but 7. Days active in grassroots building, not 3, but 4. Add another hour onto what we've been doing. Households engaged, up from 7 to 11. Contacts gained, plus 4. And move some things down.
We went to No James.
Don't worry, I'll show you what I've updated once I'm done with it. Gonna do plus. All right. Group chat of 20 to 30. Oh, that says 20. There we go. Let's make that smaller. Hello, hello, hello. What's going on? What is happening? I just want a plus sign. I just want a plus sign. I don't know why it's so hard. Okay. So we got that slide updated. We just need to sneak it into our slideshow. What's up, chat?
Oh yeah, by the way, I'm playing Ori.
And Laura's playing Ori tonight. Laura's been showing me Ori and the Blind Forest, and it has been very fun.
And sometimes annoying.
Grassroots. There we go. So now we've added our new grassroots updated slide. We can share it real quick. What? That isn't the right thing. Why does it want to show the wrong image? That's very weird. Ah, there we go. Ta-da! Okay. We've got an updated grassroots slide. Today was another day of grassroots community building so that we can hopefully eventually get to political community building, but first you got to do your
Yeet,
personal community building.
yeet.
Um, so it's been officially a week since we launched the channel. Happy birthday. Happy week birthday. We've done 4 days of community building. Three were just blocked by late nights of work. Um, but in total, in those 4 days, we've been active for a little over 3 hours. When you're meeting people, it can be a lot of talking. Sometimes you can have conversations that go for 30 minutes standing at somebody's door. But we are now in the double digits. We've engaged 11 households on our street and gained 10 contacts plus today. Somebody mentioned to me the chat of parents of up to 20 to 30 people. I don't know how many households that
20
is.
to 30?
That's right. So that wasn't just one contact we made. He made it clear that if we did a community event, I would have access to that group chat so that he could invite more people. Uh, and I'm listening to myself. I would like to stop listening to myself. If I close this, does that work? Where is that audio coming from? Aha. There it is. Okay. There we go. Now I can see concurrent viewers and everything. Okay. So the one guy I talked to got a connection to a group chat of 20 to 30 parents, and he made it clear that if I made a community event that those people would want to know, and he would be linking me up with that either only through him or if I could get in on that group chat, because I myself am a parent in the neighborhood. All the kids go to the same school. So that was a big get today. That's a bunch of people. And I think it's probably not going to be too long before we can make our first community event, actually get people together. I would like to at least finish my street before I do that, and so that might be in another couple sessions. Getting there, but heck yeah, we maybe have another political ally I have noted. I would have to talk to her a little bit more before I can be sure. We talked about it just a little bit, but um, she was pretty cool. So good stuff. We're doing it. We're really doing it, and you can do it too. Build your communities. People are more willing than you would think to have community. So, just so you know, my go-to bit these days is oh, I got chat. Hey,
Hello, chat.
you're concerned that even with enough outreach, it'll be impossible to get 34 states to agree on anything. I think that is less true than you would think. I mean, I think it is very.
Well, people may
Okay,
have
hey, steady,
arguments.
steady. Bump my desk.
Well, people may have arguments. The arguments are just gonna be like specs that barely stand out, but arguments can be sorted out. And
Arguments can be sorted out.
I mean, not really. I don't know what I'm saying anymore.
Well, that was good input, Laura. I think I see where you're going. Yeah, arguments can be sorted out. We I need to hide this. We got two different issues that we have to deal with. The first is making a convention happen. That's probably, I think, the hardest. It's not going to be an easy task, but if it can't be done, I don't know what else to do. So the main goal is just to push for that. That's it. Beyond that, once you get a convention going, I think you'd be surprised to find how easy it is to get a group of states to agree on something. I think it might be hard to get a group of 34 states to agree on an amendment, but to agree on a constitution, I don't think it's that hard. There are a lot of things that we agree on a very fundamental level that I think we forget about. Those things are like how we put restrictions on our legislators, how we restrict our executive, at least how we think they should be limited. And there are more issues these days that we agree on that we've developed in the last 250 years. Like we think there should be term limits. We think there should be age limits. We think we're aware of more opportunities to have some transparency into what our government is doing, what kind of accountability we need. The role of the judiciary, for one, like we take it for granted now, but that's actually not in the Constitution in a lot of ways. The role of the judiciary is very undefined in the Constitution itself. And so I think there are some ways that we can better clarify that so that we, as 34 states or 38 states, actually agree on it. In recent memory, from what I can tell, 32 states is the max in agreement for the Electoral College. Obama only won 29 states. I'm not sure what you're trying to say. 32 states is the max in agreement for the Electoral College. So you're saying in the Electoral College vote, 32 states agreed on who to vote for the president? But when you talk about it that way, you're talking about coming down to partisanship. And so the way I differentiate those things is we have a lot of differences on policy. What I think we lose sight of is polity. Polity is the true American way. I always say there is no such thing as American policy. There is only American polity. Polity is your system of government, system of governance. How do you define what the people's power is? How do you define what the state's power is? How do you define what rights are? And how is government carried out? That's polity. And I think we have a lot of agreement on how polity works. Do you think we couldn't get an agreement on release of the Epstein files? Do you think that 38 states could agree on that? I had wanted to add a slide today. What slide was it that I wanted to add? It was a you should know slide. Ah, I remember. Let's do some slide work. I think a singular representative from 50 states could agree on that, but implying that a single representative is an entire state is another thing. Well, single representative is an entire state. So what you need is a state legislature that could vote to propose an amendment or to hold a convention. And this should not be all the way out there. There we go. I got a bad cough. So you need a legislature to vote, and so then you need a majority of that legislature. So if you had a state legislature that was saying, yes, we need to make an amendment to release the Epstein files, then a majority would make that call. And if you had 34 states do that, then it would put it forward to a convention, or you could do the usual route of an amendment that wouldn't call for a convention.
I'm back.
Welcome back. Either way, you need 38 states. And then if you can get 38 states, state legislatures, or 38 state conventional, what do you call that? Delegations, convention delegations to agree on it. You don't need a unanimous agreement from every single one of those. You just need a majority delegation or legislature to pass it. So preferably, you would be able to get majorities that would agree to release the Epstein files. And if you didn't have majorities, that's why we're working on grassroots movements, because we need representatives who actually answer to the people's needs. And if we aren't participating as a group, if we aren't participating as communities, then what are we even doing anymore? We have lost sight of what it means to participate in American politics. We are letting people take over our processes, and we can't do that anymore. So let's make a you should know slide. Duplicate it. You should know. Yep. 2 T's and committed.
Yoink.
That's a perfectly legal way to put that statement. Unanimous jury determined it to be legal fact that Donald J. Trump committed an act that is legally defensible to call rape. Yeah. Why are the Epstein files sealed? I'm not entirely sure what that means off the bat. I assume that we're asking why they are not public knowledge as it is. Um, and that would be, I think, for a couple reasons that it could possibly be. I would need to verify. And as always, I am happy to admit that I don't know. But there are a couple reasons it could be. One could be that it's the subject of an ongoing investigation, and ongoing investigations are not made public knowledge. Um, the other could be because it's part of a judicial deal with a former um, suspect, part of a plea deal, something like that, where the knowledge was not made public as part of him giving some kind of information or something like that. But we can research that. So, let's finish doing this first. Did not want to open Copilot. All right, so I believe that should just show up in that file now. So let's pop back over. Let's go to research. NetDad, can you hear the music? How's the volume on that? Oh, now it might be gone. I guess it wasn't working on the other one either. Let me see if I can fix that. Cannot hear music, but I have my own. Okay. Well, I am trying to make music show up. Why isn't it, though? Huh. It was working last night. Not sure what I'm doing differently. Mm-mm-mm. Can't get it to work. Love having technical issues when I'm trying to get stuff done. Let's just get rid of this entirely. Add. And suddenly it wants to work. Okay. Can you hear that? I can see the OBS audio bars moving. I'm not sure how loud it needs to be for you to hear it. Well, you let me know if you hear it at any point. Okay, we're going to move over to doing some research because we've got a question. That's our first research question ever, so we're not going to shy away from it. How can we use AI to do this responsibly and ethically and not just have it answer our questions the way we want them answered? We ask neutrally. First, we need to clarify what files we're talking about. Then we need authoritative primary sources. Good. And we can look into news sources, which is where things get a little stickier when it comes to being objective. But we can work on that. Notice what's not on this list: Twitter threads, YouTube conspiracy channels, anonymous leaks. That's good. And understand legal standards for sealing. Woo, it's making things complicated on us. Okay, so I think we need a research document. This is a very thorough step-by-step process. Boy, you want us to spend 4 hours looking at this? Man, that is a long research process it's asking us to do. Take a few hours to do properly. Let's imagine we need sufficient resources to have base level confidence until our initial resources are challenged, at which point we can dig further. Okay, so next we need an actual research document. Let's put this away for a second until I can just do another. Let's go to Google Drive, make a new folder. Where do I get a new folder? Dude, I want a folder. Huh. There we go. Man, I feel silly. New Google Doc. Let's make a new research topic.
Favorite chase in the game is so hard to get to.
It's so hard to get to.
Yeah.
You're having difficulty getting to it?
Mm-hmm. I'm in the ruins. Now all I need to do is just get to it.
Are you putting the
Random
random
share.
share? Okay.
It's back.
Now let's add a window capture, research document.
I shot.
What's up?
Nothing. Hey there.
What's up?
Random chairs looking a little suspicious.
Oh, I got it. There we go. It doesn't want you to see the Bill of Rights. That's the thing. Okay. What? There we go. So let's go back to our research document. Subtopic. Where are the bullets? There we go. What are the Epstein files?
Oh no. Now they're even more suspicious.
There's a random chair among us.
That's a random chair.
There we go. Amogus. Multiple types of files exist. Let's check out. From Britannica.com.
I found the imposter. I found the imposter.
Random chair is imposter. How do I get this centered? Because I can't. This is an obnoxious website for this purpose. If I... That's not what I wanted to do. Oh my god. Wow, this is awful. There we go. The Epstein files is how the world has come to know the thousands of pages of documents related to criminal investigations into sex trafficking by financier and friend to the rich, famous, and powerful Jeffrey Epstein. What's in those files, who is named, and in what context, and whether they should be released to the public became a topic of obsessive conversation on both sides of the political aisle after Epstein's death in 2019. But in 2025, those questions and others roiled the second administration of U.S. President Donald Trump, as even some of Trump's most loyal supporters expressed a sense of betrayal at his administration's reluctance to release information related to the case. Don't care, don't care. I do appreciate this research question because it's not one that you tend to dig too much into as like, what do you mean when you refer to these documents? So we need to make that more specific. Let's see, does it give us a... 2020, Ghislaine Maxwell was charged with a variety of sex crimes, including trafficking, conspiracy, transporting minors for the purpose of illegal activity. She was convicted in 2021, sentenced in 2022 to 20 years. It's during this time that some of Trump's most ardent supporters, some of whom would go on to serve in his second administration, called publicly for the release of the Epstein files. But what are we talking about when we refer to those? Lasagna, you can't lean against my chair like that. Where is... Early in the second Trump administration, the release of the Epstein documents seemed imminent. In February 2025, Attorney General Pam Bondi invited a group of MAGA activists to the White House, where she distributed binders labeled the Epstein Files Phase 1. Although the binders included about 200 pages of documents, little of it was new. Yeah, I remember that. On July 7th, the Justice Department issued a 2-page unsigned memo that stated there was no client list, Jeffrey Epstein had killed himself, and no further disclosure of the contents of the Epstein Files documents would be appropriate or warranted. Gotta wonder why it's unsigned. Nobody wants to put their name to that legally? Ugh. Let's go back to our AI. Maybe that can get us something faster. On the question of what are the Epstein files exactly, can you provide a shorthand list of what the term generally refers to. No, I'm all for it. Like, this is what we need to practice. We need to be practicing how do we find correct information. And that's something we haven't had the opportunity to do yet on stream. And it's what I want to do on stream. And that means we need to we need to make a stream habit of how we do this. So we're gonna ask our. I haven't addressed it this stream. I need to address it every stream. On this stream, we are going to be discussing ethical and responsible use of AI as a research tool. We are not going to pretend that people these days are not using it. So that means we need to figure out how to use it appropriately. So we're going to be doing it live on stream, and you can see how I'm doing it. I regularly do this for research. The thing you need to learn is how to not lead it to give you answers that you want, because AI is not a source. AI can collect from sources. It can even research. But the problem is that AI isn't designed to give you accurate responses. It is designed to please you. Is my AI not on screen? Thank you. That's because of that stupid other tab that I opened. It got all weird. Alright, let's fix it. Stop. There we go. Let's get it back in here. And I need my search box. Lasagna, I can't give you attention right now. There we go. Let's get our input bubble down there at least. Thank you. So, step one is to prompt your AI neutrally. Do not say, "Can you give me answers that tell me this?" Don't do that. It will make things up. Believe me, I'm an attorney. I know hallucinations are a thing. Hallucinations are what it's called when an AI makes up sources, because the AI just tries to please you. It doesn't try to give you accurate responses. So you have to tell it that to please you, it needs to be neutral, and it needs to give you actual sources. So the first thing is to phrase things neutrally. Tell me, assess this. If you even need to go further, say assess it neutrally. After that, you want to double check what it gives you. You can ask it specifically to give you sources. That kind of forces it to try to find things, but you still have to double check. Because especially in the realm of law, when it gives you hallucinations, it will give you legal citations, and those will look legit. Oh, hey, if you're back, NetDad, do you hear music now? AI will give you legal citations, and those look legit. Just like you get in the habit as a lawyer, if you see something in legal citation format, you go, "Oh, that's a real case." It even cites what line it's referring to. Okay, let me try. Is it at a good level, or does it need to be heard more? But there have been situations where lawyers have cited to citations given to them by an AI, and they're just completely made up. They don't exist. It's cases that have never happened with things that courts have never said. Cool. Love to hear it. Thank you. So here's what we're gonna do. We're gonna ask it to not make us research from scratch, because that could take us way longer than we want to spend to get our answers. So we're gonna say, answer this question directly for us. Give us sources, and then we can move on from there. And if somebody wants to challenge those things, then we can dig in deeper. Because that's how you should be framing your epistemology. Believe things if you have evidence for them, and then don't let go of those positions until you have sources and evidence that outweigh the evidence you have for the other solution. believe things when you have the strongest evidence for that thing. So we're going to start with a foundation. Can you provide a shorthand list of what the term generally refers to and provide sources backing up your conclusions? And since I haven't talked about it this stream, I have prepared this AI to be live on stream with us. I've formulated it to be a team of characters that can check each other, check me. I have even given it instructions like from the beginning. I need you to check me, don't just agree with me. And these characters are all based off of characters from American history. We've got Franklin D. Roosevelt. We've got James Madison. Looks like we're not getting any input from anybody else right now, but we've got Abigail Adams, Thomas Jefferson, etc. Frederick Douglass. Okay, what are the Epstein files? Civil lawsuit documents from Giuffre v. Maxwell. What? Did you just throw ice at me? Lord, did you just throw ice at me? Okay, here we go. Let's keep going from here. Category 1, civil lawsuit documents from Giuffre v. Maxwell. Court filings, depositions, exhibits from defamation lawsuit filed by victim Virginia Giuffre against Ghislaine Maxwell in 2015. Largely unsealed in stages from 2019 to 2024, totaling over 4,500 pages of documents made public. What's in them? Yeah, let's just put this all in here. It's good shorthand. So these would not be documents that are unsealed, it sounds like, or that are sealed still. So if we need to verify this, we can look at federal court dockets from SDNY. But it sounds like we don't need to. Much of this material was sealed during litigation to protect privacy of third parties who were named but not directly involved or facing untested allegations, with unsealing beginning in 2019. So remaining research question. What remains sealed? And let's just move on from it from there. We've got what we wanted from that. I don't feel like we need to check that further. We know that there was a... Well, let's look up Giuffre v. Maxwell real quick. Just from a quick AI overview look. We're in our... Let's pull that way over. Man, that stinks. Let's just... Okay. Need to be able to see what I'm looking at over here. Hi, lasagna. Giuffre sued Maxwell for defamation in 2015 after Maxwell allegedly called Giuffre's statements obvious lies. Where's my cursor? Yep. Pull that back out a little bit. There is no easy way to do this. At least I haven't figured out the easy way yet. Case was settled in 2017 for an undisclosed amount. Despite the settlement, third parties such as the Miami Herald sought to unseal the extensive documents from the case. Unsealing efforts led to ongoing legal battles to make the sealed documents public, with some being released in batches while others remain sealed. The case, while a civil one, is significant because the unsealed documents have provided detailed information about the operations of Epstein's trafficking ring and implicating Maxwell, Epstein, and other associates. The documents have also provided context and details about Giuffre's experiences and her claims against figures like Prince Andrew, who recently gave up all his titles. Weird. Okay, back to our research document, or our research AI. So it sounds like each of these categories is going to have a different answer, NetDad, for what you're asking about, because we're looking at several different cases and investigations. So, category 2, federal criminal case records. Documents related to federal sex trafficking charges against Jeffrey Epstein filed in 2019. Epstein was arrested July 6, 2019 and charged with sex trafficking of minors and conspiracy to commit sex trafficking of minors, but died by suicide on August 10, 2019 before trial. Did I put the quotes around by suicide? That's not. Don't do that. What's in them? Indictments, charging documents, some investigative materials, evidence lists. Key limitation: case never went to trial. So much evidence was never presented publicly. DOJ released an evidence list in February 2025 showing unreleased records, including visitor records to Epstein's private island and wiretap records for Maxwell. Well, there is a pretty solid list of things that we don't have. Unreleased records. Source verification, U.S. Attorney's Office, SDNY case files. Category 3, grand jury transcripts. Secret testimony before grand juries that investigated Epstein. Status. Federal judge in Florida denied DOJ request to unseal grand jury records related to investigations in West Palm Beach from 2005 and 2007, citing strict secrecy rules and narrow legal exceptions. Well, that just stinks. This is federal judge in Florida. Well, you know what could undo that? An agreement by the states. There are no restrictions that are outside the bounds of what the states can say must be done. Because the restrictions of the federal government are made up by the states, and the states can do away with them. What's in them? Theoretically, witness testimony, prosecutor questions, evidence presented to the grand jury. Key limitation. Grand jury transcripts represent only approximately 5 to 15% of total case records, according to historical document expert Matthew Connolly. Why sealed? Federal rules protect grand jury materials under strict secrecy rules, with only narrow exceptions permitted under 11th Circuit precedent. Article 5 says, what's an 11th Circuit? I don't recognize that authority. Source verification. Federal Rules of Criminal Procedure, Rule 6E, Judge Robin Rosenberg's July 2025 order. This is a lot. There's a lot of things that make up what the Epstein files are. I don't know how many people have looked into what that term means, NetDad. Killer question. Category 4, Florida State Grand Jury Records. Now that, if Florida says no, you can't get your hands on. Unless the states agree that the new version of the federal government has access to state records, which I don't think is a good precedent to set. I don't want this. I want this to go away. Huh. Need to make a new playlist real quick. Oh, no. That's it. Right there. Okay, how do I get to my playlists? Okay, there we go. Back to it. Status. Florida Governor Ron DeSantis signed bill in February 2024 allowing release. Palm Beach judge released records in July 2024, so these don't appear to be sealed anymore. Records showed prosecutors heard testimony about how Epstein sexually assaulted 2 teenage girls before giving Epstein a plea deal. No longer sealed. Next category. FBI investigative files. Federal Bureau of Investigation case files, evidence and investigative materials, status partially released with heavy redactions. Now, that's the one we're talking about where Trump's name has been removed thousands of times, supposedly. What's in them? Files include large volume of images of Epstein, images and videos of victims who are minors or appear to be minors, and over 10,000 downloaded videos and images of illegal sexual abuse material and other pornography. Yeah, there's the heavy stuff. Why sealed? Much material is subject to court-ordered sealing to protect victims, and FBI will not release child pornography or sensitive victim details. I mean, good reason for that. But content could be, not the content itself, but just the explanation of what the content is could be made public. It would be hard to verify, though. Because if you had to verify, you would actually have to know for yourself what was in it, and nobody really wants to know that. What FBI says doesn't exist. FBI found no evidence Epstein kept a client list of associates or that he blackmailed prominent individuals, and concluded no investigation into uncharged third parties was warranted. Which was opposite of what they said before. Category 6. Oh, yeah. Epstein's non-prosecution agreement, which was shady as heck. Alex Acosta, our favorite non-shady U.S. attorney. Miami Herald's 2018 investigation exposed details of this agreement. Democrats subsequently called for Acosta to testify and for DOJ to investigate and release records. It's another thing that we need to know more about. Oh, no, down here. Yeah, no kidding. Inappropriately lenient. Source verification, Miami Herald investigative series. Federal court records. Flight logs and contact records. Private jet passenger manifests, address books, visitor logs. Some flight logs from Epstein's pilot and Epstein's address book have been made public, including multiple contact numbers for various individuals, including Donald Trump. What's in them? Names of people who flew on Epstein's planes or had contact information in his records. I believe Donald Trump is in there with multiple different phone contacts. Key limitation: presence on flight log or in address book does not indicate illegal activity or knowledge of crimes. Source verification: various court exhibits, media reports with source documents. So we got, what, 3 categories left? Category 8, Ghislaine Maxwell case records. Federal criminal case against Epstein's co-conspirator. So this is different than Giuffre v. Maxwell. One was a criminal case, and the other was a civil case. Maxwell was convicted in 2021 on 5 federal sex trafficking charges and sentenced to 20 years in prison in 2022. She is currently appealing, and she was moved to a lower security prison where supposedly, I believe, prisoners were warned not to mess with her by people in charge. That's very questionable. Trial transcripts, evidence presented at trial, sentencing documents. Why partially sealed? Some wiretap records and other investigative materials remain sealed. SDNY again. Category 9. Civil settlements. Prince Andrew and others. Well, good luck unsealing civil settlements. Prince Andrew settled lawsuit with Virginia Giuffre in 2022 for an undisclosed sum after she accused him of rape when she was a teenager. He denied the allegations. You're not getting your hands on that. And last of all, garbage. Trump administration phase 1 release February 2025. Documents distributed by Attorney General Pam Bondi at White House meeting, which I believe is just going to be previous stuff. Binders labeled Epstein Files Phase 1 and declassified contained about 200 pages of documents, but little was new. So summary, what the Epstein files mean. Be referring to any of these 10 categories is just why conversations get confused. Most commonly referenced are Giuffre v. Maxwell, federal grand jury transcripts, and FBI investigative files. Oh, Abigail, no. Gosh, I can't type right now. Go away, Norton. Nobody wants you. So Y sealed. Ick. So layer 1 of our answer is civil settlement confidentiality mechanisms. Private contractual agreements between parties in civil lawsuits. Wait, what's going on here? There we go. This is black. Legal basis, freedom of contract. Parties can agree to confidential settlement terms. Prince Andrew, blah, blah, blah. Okay. Hey, stop. Layer 2 is grand jury secrecy. Federal Rules of Criminal Procedure, Rule 6E, automatic secrecy for grand jury proceedings. So that's a big reason as to the why. And then you can break down the why are grand juries secret. Protect witnesses from retaliation, encourage candid testimony, protect reputation of people investigated but not charged, prevent flight of suspects, protect integrity of ongoing investigations. This is not special for the Epstein situation. This is regular business as usual for grand juries. Let's see what Abigail has to say here. Here's where it gets suspicious. According to historian Matthew Connolly, grand jury testimony likely represents only 5 to 15% of total case records, yet the government is using grand jury secrecy as the primary excuse for not releasing materials. If it's only 15% at top, where's the rest of it? They're hiding behind a legitimate rule that only covers a fraction of what they're refusing to release. Layer 3, victim protection sealing. Now, Dad, I hope you were hoping for a complicated answer. Victim protection sealing. Court orders sealing specific documents to protect victim identities and prevent re-traumatization. Much material is subject to court-ordered sealing to protect victims. Names of victims who were minors when they suffered abuse were not released in unsealed Giuffre v. Maxwell documents. It's typically a legitimate reason. I'm slightly satisfied. Well, hopefully you'll be more satisfied when we have... Here, let me read off all the layers for you as to why are they sealed before we continue finalizing our notes here. One reason, civil settlements are confidential always, and you're never going to touch that. There's no reasonable system where two people can't agree to confidentiality privately. It's outside the government's control. They've made law with each other. That's what contracts are. It is self-invented law between two parties, two or more. So Maxwell and Jouffre made up law between each other where they couldn't talk about this publicly. Standard grand jury secrecy in the federal context. That's normal operating procedures. Grand jury stuff is kept secret for a variety of reasons listed here. We went over them a second ago. Reason 3, courts protect victims, so they seal information that would make life hard on victims. Reason 4, child sexual abuse material, more stuff that courts do to protect victims, specifically in the context of material that involves children. Not just to protect the victims, but this is just illegal materials, period. These materials exist in the world, and they are always illegal. So you can't just go releasing them to the public. Third-party privacy rights. That's less legitimate of a concern when it comes to stuff like this. This is public interest situation. Layer 6, protecting ongoing investigations. Layer 7, executive and prosecutorial discretion. It's another one of those reasons that should be overcome by public interest. Number 8, it doesn't exist. Okay. So let's we don't need to go over all these anymore, like we just ran through them quickly, but I do want to record them for posterity. So I'll just shoot through that real quick. And then we can get to the question that I care about, which is which of these could be appropriately done away with a national convention. And it looks like we're not going to get to editing video scripts tonight, but I'm okay with that because we got our first real research question, and I love that. I'm very happy with that. Don't need this. So thanks again, NetDad. So confused by your username. It seems like the deeper we get into these layers, the AI is getting more suspicious of it being a real concern. I love that. Yeah, I love this claim. The FBI was like, there is no client list, there is no Epstein files. It's like, okay, like you know what we're referring to though. Like you can't just say, oh, he didn't keep a binder called client list. There we go. I like that. We have a synthesis. Legitimate legal mechanisms are being used beyond their intended scope to justify withholding information that could be released. Complicated answer. So let's get to the last question. How effectively and separately, appropriately, could each of these be dealt with by a constitutional convention? Let's stop this. Imagine, because of public interest in this particular case, we wanted by constitutional convention to deal with this case specifically, so America at large knew the truth behind this situation. There we go. That's more specific. Constitutional malpractice, you think so? Bills of Attainder. Article 1, Section 9, Clause 3 of the Constitution prohibits bills of attainder laws, single out specific individuals or groups for punishment without trial. Constitutional amendment targeting the Epstein case specifically would likely violate this principle, even though it's amending the Constitution itself. The founders were adamant about this. Parliament used bills of attainder to punish political enemies. It's one of the specific abuses the Constitution was designed to prevent. Could you technically pass an amendment that says release all Epstein files? Maybe. Should you? Absolutely not. I have to entertain this argument. This is throwing at us a potential constitutional approach to civil settlement confidentiality. Settlement agreements in civil cases alleging criminal conduct against minors shall not include confidentiality provisions that prevent disclosure of the alleged conduct, though victim identities may be protected. You know, I'm not opposed to that. Huh. Grand jury secrecy. Grand jury proceedings shall be made public within X years of conclusion of related prosecutions or immediately upon death of all defendants, except where disclosure would identify victims of sexual offenses who have not publicly come forward. That's fair. Victim protection ceiling. Yeah, I don't. Victims of sexual offenses shall have the right to protection of their identities in legal proceedings unless they explicitly waive this protection. This protection shall not extend to sealing of testimony, evidence, or allegations that do not identify the victim. That's fair. I mean, yes, like, I don't want to overrule that. Third-party privacy rights. In cases involving allegations of federal crimes, third-party privacy interests shall not prevent disclosure of court proceedings, testimony, or evidence, except where the third party is a victim, minor, or where disclosure would violate established privilege. Mere association with or mention by a defendant does not constitute grounds for sealing. That seems too broad to me. Ongoing investigation claims could require transparency about investigation status. Yeah. Material sealed on grounds of ongoing investigation shall be unsealed within 5 years of the conclusion of prosecution unless the investigating agency publicly certifies specific ongoing investigative need. Such certification shall be subject to judicial review and shall expire after 2 years unless renewed. That's fair. All records of federal criminal investigations and prosecutions shall be presumed public and shall be made available within X years of case conclusion, except where specific statutory exemptions apply. Agencies declining to release records shall bear the burden of justifying withholding. Sure. So, I mean, yeah, okay. Constitutions should establish principles, not handle individual cases. All right. All right. I begrudgingly accept this. It seems like we could do get the same need fulfilled by doing it in a constitutional way that outlines principles about cases like this. What do you mean the constitutional amendment wouldn't help if the executive branch simply defies it? Oh, okay. Yes, but that's part of the problem, isn't it? We need to change the structure of the current executive branch. Yes. Don't tell me what my project's for. Oof. Being called out. Okay. Well, here's what I'm going to do. I'm going to copy all this feedback on how a national convention can respond to these ceiling issues, and then I'm going to call it a night for tonight. Don't do that. There we go. Love it. Okay. So with that, we're going to call it a night. I appreciate the opportunity to actually do some live research. Thank you for that, NetDad. I'll be back tomorrow. I think I'm going to make this regularly, I'll call it a 9 p.m. Central regular unless things change. Yeah, I think that's a good strategy from here on. And so I will make an announcement if things are any different. I'll still make announcements about 9 p.m. streams, but I need to start making a regular schedule for this. So that's what we're going to do. Tomorrow night we're going to pick back up with editing a script for making our first video, and beyond that our first round of videos, so that things can actually be shared and be informational, succinct, educational, informational. Okay. With that, I'm Know Nothing Attorney. As always, I profess to know nothing and aim to have a high degree of confidence in everything. I urge you to embrace knowing nothing with me, because it's only in embracing our lack of knowledge that we can learn anything. And we should be learning together. As always, I leave you today letting you know that I'm proud of you. I don't need to know who you are. I don't need to know what you've been through. What I know is life is hard. It's always been hard, and it always will be hard. And the fact that you are still here after everything, and in the face of everything to come, you continue doing it. You continue to be here, succeeding, pushing forward. And that's always remarkable. I'm proud of you. Have a good rest of your night, and go conquer the week. See you tomorrow.